For you.
Thank you very much, Mr Chair. To speak to part one of the Companies and Limited Partnerships Amendment Bill, can I first of all thank the Minister and the Chair for taking a call to respond to some of the issues that were raised by my colleagues. He did respond quite well, actually, to be fair. David Parker and Dr David Clark, first of all acknowledging that the rather large SOP that layers over Part 1 isn't, in fact, the big document that was claimed earlier, but has worked into the new RT version of the bill. So we do acknowledge that, Minister. And also the point that David Parker, the Deputy Leader, raised around trying to get the balance right between companies and directors who look to take action, I guess, in what you would call desperate times for some firms, and where they have to consider whether actions may be considered either reckless or action that is needed to take a company or a partnership which is in a precarious position back into a safe position, and also where the line may be drawn in terms of the willingness of those directors to take some action which they may deem necessary, but which they may think may not be the wisest move if that action may be seen as a criminal action under the law as it was first drafted. So thank you. Thank you very much. Thank you very much, Minister, for taking the opportunity to answer some of those questions. But as I mentioned first, thank you for that. But as I mentioned first, Mr Chair, there is a rather significant SOP that layers over Part 1 of this bill. And while I wasn't on the Select Committee, I think the way that the bill was presented back to the House before the SOP 465 was added to this bill, the bill in its current form, the Select Committee did find, I think, and the officials who were dealing with this bill did find themselves in a bit of a conundrum because they thought there were still issues about getting the balance right in terms of being specific about the criminality that may be acted, and also making sure that there was some, I guess, in layman's terms, wriggle room there for directors to make sure that they could take action that they saw fit if they were in dire straits with that firm. And I think in the commentary of the bill, the Select Committee did point that out. And if I can take the opportunity, Mr Chair, just to quote from the bill to say where the Select Committee said, however, we are aware that the bill could be perceived by directors and their advisers to criminalise legitimate business risk-taking behaviour. We therefore sought an appropriate balance between encouraging positive entrepreneurial behaviour and imposing clear and effective sanctions on behaviour that crosses a criminal threshold. But the commentary went on to say we don't recommend any changes other than minor drafting and would support further consideration of drafting of these new offences to ensure the provisions are expressed in a way that provides clear guidance to directors and does not have a chilling effect on a legitimate business. So I think what you've got here, Mr Chair, is a strange position where the Select Committee identified that there was a problem, that things that they thought the legislation had to be much more specific in terms of what the criminal actions might have been, but they couldn't offer up those specific, I guess, a remedy for that conundrum that they found themselves in, and which I guess meant that the SOP 465 had to come into play. We've looked at the SOP, and I understand that we believe that it does strike the right balance between to make sure we are very specific about the criminal behaviour that can be outlined and, as the Minister said, around intent, where there could be actions taken by directors, where there could be criminal behaviour, and the other side of the equation where drastic action needs to be taken by directors to ensure that a company can stay afloat. Mr Chair, this bill does have the support of the Labour Party. We do know that New Zealand has a very good reputation in terms of its ability for people to come here and do business, but we also know that lately there have been instances that have gained not just local media attention but also global media attention, where people have taken it upon themselves Mr Chair, to exploit the good, Mr Chair? Mr Chair, to exploit the good reputation that New Zealand has and using shell companies to take advantage of the legislation that we have in our good name. So we do believe that this piece of legislation is necessary to make sure that that reputation stays intact. But we do know that this legislation has been on the order paper for some time. I believe it was introduced in about 2012, halfway through that year. So 2 years later, we've got a piece of legislation that has had the support of this House to quite a strong degree being put forward in the House. It does beef up the rules at the companies, around the Companies Act, and gives more powers to the registrar, which has had the full support of this side of the House for some time. So we question why it has taken so long to get to the stage where it is now, where it progresses to the final stages of becoming legislation. It may be the fact, Mr Chair, that we're very unlikely to see any controversial legislation come through this House now, because we've seen one member of the House, former ACT leader John Banks, have to resign. So what we may get is, Mr Chair, what we may get is a lot of rather what you would call mundane legislation that the government may have to start putting through this House, because it simply does not have the numbers to get anything controversial through anymore. So what you might be seeing is, a government petering out over the next 2.5 months here in the House, simply not being able to implement its far-right agenda because Mr Banks is no longer here anymore. And that is, I guess, upsetting for them. But for good on this side of the House, because as we've seen, the kinds of legislation that have been passed with the support of Mr Banks have concerned the sale of quite a number of our state-owned assets, and also a controversial move to introduce what they call partnership schools over there, but are quite well known as charter schools on this side of the House. One other part of this legislation, in part one, that we do support, Mr Chair, is the increase of penalties for any directors that do undertake any criminal behaviour, which is specifically laid out in part one. Those increases see a maximum imprisonment sentence of 5 years, I believe, and also a maximum fine of $200,000 for each offence occurred. And I think that does send a pretty strong message to anyone who is either here in New Zealand or overseas, that if they're caught contravening this Act, that a pretty harsh penalty will be imposed upon them. Mr Chair, just going back to be specific about part one, I think it's Part 4, which introduces a rather large Part 183 in the Companies Act, which gives quite new powers to the Registrar of Companies to investigate and deal with non-compliance with the Companies Act. And this includes, I understand, Mr Chair, the power to flag companies on the register that are under investigation. That is a new power. It's a good power but given to the registrar because of some of the concerns that I have mentioned before around some of the, and I think it's more overseas interests who are coming here to use New Zealand companies as shell companies to basically act illegally under that shell company. It also will allow the removal of companies from the register if they provide inaccurate information or persistently fail to comply with the Act. I guess we hope that the Registrar of Companies is given the resources to be able to monitor that quite closely, because I think if you have got well-resourced people, again, probably from overseas, who are taking advantage of that loophole, you want to make sure that you are being able to monitor that quite closely. And also, Mr Chair, the Registrar will be able to ban directors of those companies from taking part in the management of any company for up to 5 years. I think that just goes without saying that anyone who gets himself involved in that kind of behaviour isn't the kind of person that we want to be being a director of a company here in New Zealand. So, Mr Chair, we do support this bill. It does take some good measures to ensure the reputation of New Zealand doing business in New Zealand is upheld. We do have some concerns, as I said, around the timing of the bill, that it's taken so long, and also the fact that it's here now so late in the piece, and why it's here, and that's quite clearly because John Banks is no longer here.
Claire Curran.
Mr Chair, why has it taken so long for this bill